everybody, we're ready to start. I would like to introduce a panel. My name is Neophytos Loizides. I'm a professor in international conflict analysis at the University of Kent. I would like to introduce the speakers of the last panel. We have a distinguished guest, George Anderson. He was introduced already by Harry, so I'm not going to read the full CV of George. A distinguished career in public service in Canada, but also someone who has managed to bridge together academia and the policy world. George has written a number of books. Today he's presenting a book that I had the chance to contribute to, a book on constitutional transitions in a number of very interesting countries around the world. And there are three major reasons why we decided, along with my co-organizers, Harry, Ishikuchu, and the rest of the team, to focus on this group. The first is that it's a volume that brings together George Anderson and Sergei Choudhury brought together a number of cases from a number of countries around the world. And being myself a comparativist, always curious to learn something from each country that has broader implications for around the world. So in this book, there is at least one lesson, I hope, for each of the one lesson that can be learned for Cyprus. At least that can be useful to us, or at least useful for comparative purposes, for discussing, or for inspiration. The second is George, along with his collaborators, have been working for many years with important policy organizations. This is a UN policy division team, political affairs team, on power sharing, where there's a Council of Europe, some of the colleagues in the team of the contributors, the World Bank, the European Union, Forum of Federations, and IDEA International has sponsored this project generously. They put together these experts. They selected people who have been working in key policy positions around the world. So in a way, the book brings together, or is an attempt to bring together, the collective wisdom of people who have been in the mediator's seat. In our work in Cyprus, we often try to understand Greek Cypriots and Turkish Cypriots, but we always fail to understand the mediators, to understand the position of the people who come to help us. And for a while, we have having a little bit difficulty in reaching out to people who have come here to mediate. So the book's an opportunity to understand their perspectives around the world. So it is a considerable effort in this direction. The third reason is that, and this is what the topic of the discussion will be today, that there are emerging common themes across case study, whether this involves the negotiation, the mobilization of different actors, the process of ratification of constitutional transition. That is very important to think when it comes to our specific problems in Cyprus. So a lot of good reasons to be listening to this panel, but most important, the speakers who are here with us, apart from George, who traveled all the way from Canada to be with us today. We have Emel Akcali from Swansea University. Emel has done her PhD at Sorbonne University. She has worked in Cyprus for many years, has been one of the prominent thinkers on the Cyprus issue, but more broadly, a number of cases. She's been working most recently on Tunisia and other cases around the world, a comparativist as well as specialist on Cyprus. Emel, before going to Swansea, she has taught at the Central European University. It's been one of the most inspirational stories in Europe for the past decades. A university that was created to bring together people from everywhere in Eastern Europe. You know what happened to Central European University recently, a very sad development that speaks to the global problems countries are facing with the rise of nationalism and the rise of populism. Finally, we have Aristotelis Constantinides, who's a professor at law at the University of Cyprus, here at the law department. Aristotle has a distinguished career, both as a legal expert, but also in the policy world. He has been involved in the negotiations in Cyprus as an advisor, so very much looking forward to his own perspective informed by his engagement, but not necessarily representing any of the sides on the negotiation on that capacity. Aristotle has done his PhD at the Aristotle University in Thessaloniki, and he has been here, as I said, at the University of Cyprus as an associate professor. So I'm going to give 25 minutes, George. Will be okay? A little bit less?
Absolutely less.
Yeah. We'll see how it goes here.
Well, thank you very much, Neo, and for those of you who are seeing this through to the bitter end today, this is the book. I was pleased. It arrived in the mail just as I was about to leave Ottawa, and it's published by Oxford University Press. I think the price in the UK is £70, so I expect it to be a pretty big seller, and I'm sure you'll all be giving it out at Christmas and so on. What I'm going to do is just give a little outline of the project and some of our major conclusions, and then we have the two commentators and we can see where we go from there. Just in terms of the background to this project, I had a year at New York University in their Faculty of Law. I'm not a lawyer, but I was in the Faculty of Law with Sujit Chowdhury, a very distinguished constitutional lawyer, a Canadian who's a comparativist. And together we worked up this project. We both had an interest in territorial politics as it relates to institutional designs. And so we decided to do a comparative project on constitutional transitions in which territorial politics were salient. But we didn't want to limit it to federal experience. We wanted to look at other cases where they were dealing with a constitutional issue but not necessarily going towards a federal structure. And we wanted to look at cases which may have succeeded in the sense of actually achieving a constitutional change, and others where it didn't result in a constitutional change. We got sponsorship, as Neo referred to, from the Forum of Federations, International Idea, a Spanish foundation called the UBAD Foundation, and from New York University. We had 17 case studies. I'll take you through the names of them in a few minutes. And what we did is we had two meetings with the academics, the people who were writing the chapters, where the first meeting particularly we focused on developing a common format. So each chapter had to address the same issues in a certain number of questions: political mobilization, process design, outcomes, and so on. In addition to the case studies, there's a synthetic chapter on constitutional making processes, another one on constitutional design, and then Suj and I wrote a very long chapter, it's about 40,000 words, at the end, which is sort of the synthesis of syntheses. That chapter has served as the basis for a much abridged policy paper, which is available online. It's on the website of the International Idea and of the Forum of Federations. It has the same name as this book, but if you are interested in reading it, it's there. The other thing that we got Oxford University Press to agree to, very exceptionally, was that all of the case studies could go online. And they're online on the website. They're being put up one a week. So they're not all up yet. I wrote the case study for Yemen, and that'll be the swan song sometime at the end of June, I think. But they're being put up one a week on the forum's website. So most of the book is available in some form or another online. The case studies through those two websites and Suj's and my abbreviated version of the last chapter is also on those websites. And the version that's on the Idea and Forum website has a little bit more in terms of policy recommendations than is in the main book. In terms of what the book's about, Fink Haysom, who's be known to some of you, has been the UN Special Representative in Afghanistan, Sudan, Somalia. In his little blurb at the back, he summarizes it very nicely. It's about the underlying logic and political dynamics that inform or limit constitutional options, especially in the context of territorial cleavages. And that distinguishes it from much of the constitutional literature, which is a bit detached from context. And I like to think it goes a little further in considering some specific choices as well that practitioners will make. We have adopted the notion of constitutional moment, which is what we were looking at. Each case study looks at a period in time in these countries where the constitutional issue was front and center in their politics, where there was an active effort to change the constitution. And these constitutional moments vary in length. In the case of South Africa, it was spread over several years, and Philippines as well, and so on. Some of them are relatively shorter term. For the Cyprus case study, which Neo wrote, the focus was on the Annan Plan, not on the whole Cyprus issue, but on the Annan Plan as a constitutional moment. The core argument really falls into three pieces, or through three. What we really came to focus on was the importance of three variables. I want to call them independent variables, but they're also dependent variables in terms of the causal nexus. The first is what we call political geometry, which is the structure of territorial and other cleavages which are salient in a country. How is public opinion divided? What are the things that really motivate people politically? And sort of, in terms of political geometry, where is it spatially, but also in terms of the size of the different chunks of opinion. Second thing, which I think we didn't anticipate quite so much when we got the second and third, we didn't anticipate that they would emerge with quite the salience that they did, was the antecedent circumstances of peace going into the constitutional moment. What led to the constitutional moment? I mean, when we started, we said we wanted to look at political mobilization, but what we found is that we very quickly were distinguishing between those constitutional moments which emerged out of a peaceful environment, normal politics, if you will, versus those which emerged out of violence. And that could have an influence on how things unfolded. And the third was the power positions of the key political actors. Very different if there's been a victor in elections or in a violent combat versus stalemates or balanced politics where people have to negotiate with one another. So that gives you the core of it, and then what we do is work our way through this in more detail. When we looked at we had 17 case studies, and we categorized, what we ended up with was identifying 4 sort of ideal types of countries that were in terms of their political geometry. The first are countries which are highly territorialized with several regions. I mean, India is a sort of classic case, but where territorial politics is really prevalent right across the country, and you have many regions, so that gives a plurality to the political geometry. Nigeria, Ethiopia, India, Spain, all fall into that category. Then we have countries which have only 2 or 3 highly salient regions. Welcome to Cyprus. But obviously Bosnia, the original Pakistan, which was not one of our case studies, could be put into that category. Notoriously tough to manage. The third type was countries where you had a relatively low level of territorialization, or maybe even extensive territorialization, but where you have one or more small peripheral regions with a strong demand for autonomy. And even in a federal context like India, greater autonomy than the rest of the country. So Aceh in the Philippines, the Bangsamoro in Aceh in Indonesia, the Bangsamoro in the southern Philippines, two of our case studies. In terms of peaceful politics, Scotland within the UK fall into this category of marginal cases, and then also the various, in northeastern India, there have been a number, what used to be Assam has been broken up into a number of essentially tribal states, which were quite relevant. The fourth ideal type is countries which have relatively low levels of territorialization. Territorial politics is not at the center of the country, but it's there, mixed in with other cleavages, and it is salient. It's one of the issues that has to be dealt with during the constitutional transition. So those were our four types, and I'll come back a little bit in a moment to talk about sort of how we saw those things affecting what happened during the constitutional transition. In terms of the conditions antecedent, whether they were peaceful and institutionalized or violent and semi-extra-legal, a key question here was whether or not you were going to have constitutional continuity. And obviously you will have constitutional continuity during a peaceful process, but in a case of a violent process, you may not, particularly if it's a civil war. The peripheral violence, so take whether it's Aceh or Mindanao or northeastern India, those cases stayed within constitutional continuity. What that meant is that the rules for how you deal with issues and constitutionalize change are already defined. You're operating within constrained rules. Whereas if you have a civil war, Ethiopia is the classic case, and the rebels win the civil war, you have a total break in constitutional, you have a constitutional rupture, and they're free to determine what are going to be the rules of the game, and in due course have a great say over the content of the ultimate constitution. You could get variations on the theme in both Nepal, which had a civil war, where part of what they had, the government insisted on constitutional continuity. The rebels insisted on a new interim constitution, so they negotiated it was a kind of two-step to get to a new interim constitution which the Maoists would accept, so the fig leaf of constitutional continuity was preserved, but it was basically a new negotiated arrangement. The same happened in South Africa, where the apartheid regime, the national government, insisted on maintaining constitutional continuity. In terms of the relative power of the actors, that's obviously critical in terms of who gets what influence. Victors in elections, victors in wars get to dictate the terms, both of the process and of the design. But what you do find in many cases is you get periodic tests of strength going through the process, and particularly if you have elections and referendums. Bolivia was a classic case of this, where they had several elections and referendums at different levels in the country, the departments or the national level, which became critical in determining the outcome of the process. Constitutional making processes, these we analyzed in terms of agenda setting, deliberation, and ratification. I'm not going to go into this in any detail at this juncture, but they take, depending on where you've come from in terms of are you coming out of a violent situation or are you coming out of normal peaceful politics, the way agendas get set is very different. The role of sometimes the agenda setting phase, particularly if it's in a violent environment, has a lot of substance in terms of what are going to be the basic terms. And when you get to the deliberation phase, as happened in South Africa, where you open it up to a broader participation, there are a number of basic principles or basic structures have been agreed. And then ratification is very important. Again, is it done simply, what is the procedure for ratification? Is it set down in the Constitution? Even if it's set down in the Constitution, sometimes there's the decision to have a referendum, or referendums, plural, as you know. And that always raises the possibility that it'll all crash and burn at the end of the process, again, as you know. I will conclude just by making a few observations on constitutional design. So obviously the highly territorialized countries with several regions, those are what you would call naturally federal countries, typically quite decentralized. Highly territorialized countries with 2 or 3 antagonistic regions, that takes you to federalism plus consociationalism, which is exactly the model we're talking about here. Countries with some small marginal regions, that takes you to special autonomy arrangements. But I mean, part of what we argue, particularly looking at the UK experience, is that it's easier to manage special autonomy if there's not too much of it, or if it's not for too much of the population. My view is the UK has got itself into a bit of a box with how much special autonomy it's given to 15% of the population, because it raised the issue of English votes for English laws, whereas most special autonomy arrangements are for 1 to 3% of the population. The UK has gone much further than any other country in giving such extensive special autonomy to such a large part of its population. And then countries which have relatively low levels of territorialization compared to other cleavages may decentralize. They may call themselves federal. Kenya doesn't get decentralized. But also one of the things that happens both in federalized countries, in federal countries and in just countries which are decentralizing, there are often important issues in terms of constitutional design as to how do you design the regions for the purpose of the Constitution or decentralization. That was a critical issue in Nepal, where they didn't have any natural regions. And it was a critical issue in Nigeria, where they made the transition from a very dysfunctional 3-state, eventually 4-state federation to 36 states. I will conclude with just some observations. We're in Cyprus, 2 or 3 observations, or questions, really. I don't know enough about Cyprus to really launch any major recommendations, but we've had a really interesting day here in terms of creative power sharing, creative ideas about power sharing at the center. And the focus has been on the executive and the lower house. And the missing element which was touched on was the upper house. I'm not a great believer as a student of federalism in the importance of upper houses, particularly in parliamentary regimes. I think they're really party houses, and in Canada we have a Senate which exists but doesn't really do anything. It's of no political importance. But I don't think you need a Senate in a federation, but there may be reasons why you have one. But it bears careful thinking about an upper house, whether you really think it's going to do something, or is it just going to be a party house? And I don't mean a party in the other sense. Is there agreement here? I mean, people have talked about extensive decentralization. Is there agreement really on very extensive decentralization? How much focus? I mean, there's been all this focus on power sharing, but of course decentralization is a big part of power sharing. So what I find in many countries which are going through constitutional transitions is that people don't really do their homework on the sharing of the allocation of powers. They get bored by it, they don't understand it, and it gets sort of done casually. Minority rights, obviously very important, and that was touched on in the last session. Schools, public services, etc., where do they stand? The whole question of how open or closed is the process here, it's a pretty closed process. I think we've heard many people today say that it should be much more open. And when I was working with the UN, I became deeply familiar with the property package. I'm not at liberty to say what all was in it. I actually thought it was a very good package. Not being an expert and not knowing exactly how it would play with everybody, but you know, why wasn't that made more publicly available? Why didn't people engage more on it? It seems to me that that could have been done, and there was a lot of public involvement, as you alluded to early on, but it was never shared as a package. It's a very creative package. Last comment, the basis of dealing with the process here is nothing's agreed until everything's agreed. That's not always the way things are done. And after 45 years, maybe it's time to think about doing things a little bit differently. Are there some things which could be done in phases? There have been countries which have had interim constitutions where they solve some issues initially and then they move to the next stage. I think there's a lot of room for thinking about phasing. So those are just some initial comments. I hope I didn't talk too long.
Thank you very much. That was a very, very useful framework, a lot of insights. I'm sure you have comments to make. I'll ask first Aristotelis for his comments. Yes, you can stay there.
Yes, sir. Thank you very much, Neophytos. And also thank you very much to you and Haris for this very kind invitation. It is a real honor for me to be commenting on the book by George Anderson and Chowdhury. May I pronounce it well? Chowdhury. And Chowdhury. Actually, before I start, because you mentioned my capacity as having taken part in the team advising the negotiator, or the Greek ship negotiator, I have to stress a disclaimer that I am here, of course, talking today exclusively in my academic capacity. Although there will be a lot of interesting things already have been said and probably will be said, but I have to make this disclaimer, definitely. I enjoyed very much reading the part of the book that I was able to read. It is 17 case studies, plus some thematic chapters. Really interesting. The methodology was a great methodology. It was a similar format to all the chapters, which was extremely helpful. It was a historical approach written by scholars from within these societies. It was most informative. I learned really many things. Thank you very much. It was it is a great book. I think it is a must-read, not only for scholars of political science and comparative constitutional law, but also for practitioners, stakeholders, all those interested in federalism, federations, ethnopolitical conflicts and divided societies, power-sharing agreements, the evolution of powers. I particularly enjoyed the fact and appreciate the fact that the book also brings together political scientists as well as lawyers, comparative lawyers, constitutional lawyers, as well as a couple of international lawyers. That would be one of my preliminary comments if I were to relate this situation to the situation of Cyprus, that at least in Cyprus, it seems that lawyers and political scientists are like ships passing in the night without even having any interaction among them, in the sense that I don't think that most lawyers dealing with the Cyprus problem, have, for example, know what consociation means. And on the other hand, I'm not sure whether many political scientists working on the Cyprus problem are aware of the legal technicalities that are very particular and very important, and sometimes dictate the outcome of negotiations. So I think that this interaction is very much needed. It is long overdue, and I very much appreciate that this book includes perspectives both by lawyers and political scientists. Now, I was asked to speak for 15 minutes, highlighting some of the issues which have already been discussed by George Anderson. So I will skip much of what I had prepared to say because I was asked to present like an overview of this chapter, as well as of one other thematic chapter, say a few things about the Cyprus chapter, and also say a few things about the chapter on Spain. So I will limit myself only to those parts of the thematic conclusion chapter by George Anderson and Chowdhury about that relate to the Cyprus, so that perhaps I can make it a bit more interesting to the audience, and also help contribute to the remarks that Neophytos will have to make. So, talking about the political geometry of territorial cleavages that George Anderson referred to, it is interesting that to illustrate this point, the authors, the co-editors in their conclusions chapter, they point to the case of Cyprus, noting that the Greek Cypriot leadership that framed the Greek Cypriot claims in terms of justice and human rights discourses, and have led them to a demand of a right to, of displaced persons to return to their properties, whereas the Turkish Cypriot leaders have offered a counter-framing to justify the new realities on the ground built around persecution by the Greek Cypriots, which led to the mass movement of population, the property rights of current users, and security concerns to counter the right of return. And the authors further note that underlying this disagreement on the framing of the conflict is a more fundamental one over how to frame the possible reunification of the island. Greek Cypriots see it as a holding together, and that is the continuation of the existing state of affairs, while Turkish Cypriots argue that it would be a coming together, that would be two states, coming together of two states to form a federation. So I think that this is indeed a good example that showcases how the political geometry of territorial cleavages involving different narratives by the political entrepreneurs plays an important role in the whole picture. I will skip the other variables, and I will move to the constitutional design that is divided. The authors present three major constitutional design options to respond to claims for the accommodation of territorial cleavages. The first is symmetrical federalism, or devolution with a majoritarian central government. The third one is a special autonomy for territories in a federal or non-federal state with a majoritarian central government. And then the second one is highly devolved federal government with a consociatial central government. And I left this at the end because this is, as you have already stated, George, is related also to Cyprus, as well as to the cases of Bosnia and Herzegovina and Belgium. Now, I found very interesting all the comments, and I will restate them here. All the comments found in this chapter relating to Cyprus, I think they are very, very topical and very crucial. Consociations are considered to be a very challenging architectural option that should be considered only in exceptional circumstances, especially if there is a major disparity in the relative sizes of the communities, because the majority may then be more resistant to power sharing, as has been the case and perhaps still is the case in Cyprus. So the authors emphasize that the minority community must be of significant size for this option to be considered, which is not the case in Cyprus. Since the Turkish Cypriot population is no more than 20% of the population, the authors argue that the Greek Cypriot community has understandable concerns about equal power sharing, while the Turkish Cypriot community feel the need for it to avoid Greek Cypriot dominance. They add that the consociational government is a particular form of power sharing in which the agreement of a majority of representatives of each community is necessary for certain specified major decisions. Belgium has a highly developed form of such federalism, and Belgium is seen as an example of a successful consociation, and Northern Ireland, at least to a certain point. But the authors also point out that in these cases, the ratio of majority to minority is close to 60 to 40 or 55 to 45. And in this respect, they note that while in Cyprus, the Greek Cypriots constitute about 80% of the population, this would make power sharing more difficult. And I would add that in practice, this has been proven to be the case. Even though, of course, there has been an agreement for more than 2 decades on political equality, and there are, of course, continuing disagreements as to what exactly this means. However, in practice, when this political equality will need to be translated into particular provisions for a future settlement, in practice, there are a lot of practical issues and problems that are being encountered. And this has to do because we're taking a general concept of political equality, which with the existing situation on the ground, with the numerical disparity that is a matter of fact. Sometimes in Cyprus it is the elephant in the room. It is not always politically correct to talk about, but when the time comes, you have to face this reality. And if you, when one tries to accommodate this with concepts such as the EU acquis and certain legal constraints that are inevitable, it's not because I'm a lawyer, I don't want to talk legalistic, but we will face them. Bosnia and Herzegovina has faced them. There have been serious issues before the European Court of Human Rights, and the European Court of Human Rights has found that certain aspects of the Dayton Agreement were in violation of the European Convention on Human Rights. So there is no option but to make every effort to accommodate these realities with the legal standards, the European legal standards. And in this respect, I would consider that, especially when it comes to Cyprus, I think that all comparative examples are great and most useful, but not always very relevant for the case of Cyprus, because in Cyprus we have two separate issues than non-European territorial cleavages. Cyprus is a member of the European Union, and Cyprus is also party to the European Court of Human Rights, the European Convention on Human Rights. So there are particular constraints that are there because of membership in these two institutions, and that have to be taken into account. It is extremely difficult to not be taken into account. And in this respect, the observation that the numerical disparity between the two communities, making it even more difficult to have a power-sharing agreement in Cyprus, is most pertinent. I think I have taken much of my time, so I will simply say a few things on the chapter by Tom Ginsburg, who is a lawyer, international lawyer. His conclusion actually is also relevant for the discussions in the current situation in Cyprus. He notes that the fact that agreement is reached does not mean that it is a good or optimal agreement. one of the themes that emerges from the case studies is that some of the bargains, which might have been the best possible under the circumstances, are institutionally dysfunctional. Indeed, poor governance may be the price for peace. We have seen this in Bosnia and Herzegovina, and this is what we're trying to avoid in Cyprus, how to have peace and a good agreement. So not a dysfunctional agreement. And if we add this, and if we take into consideration that peace agreements, these are statistics, official statistics, that a significant number of peace agreements, I don't know how much it is by today's standards, possibly around half of them, fails after certain years. We need to make sure that there will be an agreement that will not fail, because we don't know what will be the price of a failure in terms of peace and security. So, of course, we do have all these, we are already paying a price in terms of peace and security. We are having a peace which is maintained the way it is maintained, but I think that the conclusion of Professor Ginsburg that it verbalizes one of the key dilemmas also in the current political climate in Cyprus. To what extent possibly poor governance, in the sense of a potentially dysfunctional federation, is preferable to peace, in the sense that potential peace and security threats might emanate from the continuation of the status quo, which we tend to forget because we currently have peace, at least in the sense of the absence of any conflict. Lastly, saying a few things on the chapter on Cyprus, which was co-authored by Neophytos Loizides. I think it is an excellent account of the Cyprus conflict, very well balanced. Indeed, congratulations. I think it is a must read for those who want to be introduced to the Cyprus issue, the Cyprus problem. The historical account is very well balanced, very comprehensive, concise. Also, the Annan plan is very well presented. All the stakes are highlighted, and the conclusions are also quite pertinent. The UN arbitration was ultimately not a good idea. The referendum before accession was also perhaps not a good idea, in the sense that it was a disincentive for Greek Cypriots to vote in favor of the Annan plan. But then there are also various conjectures. 2004 is different than when the federation was agreed by Greek Cypriots and Turkish Cypriots back in 1977. 2014, when the negotiations resumed, when they had the joint declaration, is also different. We have the experience of being in the European Union and not having the EU solving the Cyprus problem, as was the people's, the Greek Cypriot communities at least, understanding when they voted against the Annan plan, that they had better chances within the EU. The European Court of Human Rights did not solve the problem of property in the case of Cyprus. So there are considerations that point towards some reasons for a renewed effort to ultimately to resolve the Cyprus problem, that things were not taken into, they were not done the way people thought they would be done when they voted against the referendum 2004. But I think I have taken more time than I was allocated, so I will stop here. Thank you very much.
Yeah, all right, okay. So thank you very much for the invitation. I also very much like the book. It's very informative. So the case studies, especially all these case studies, 17 case studies, are very helpful in order to understand all these, the constitutional design in societies in which territorial cleavages have been politically salient. We have kind of distributed, I mean, we have allocated how we can do this critique of this book, and I have taken 2 chapters. I have taken the case of Bosnia and also Ethiopia. There are 2 reasons why I have taken Bosnia. The first reason, of course, it is the most popular, the most known example where an international agreement has actually made ethnic cleansing legitimate. So in this case, we have an experience. I mean, we have a case in front of us, and and most of you, we have all kind of. I guess I look at the age. All of us, we have experienced. We have observed this war. We know what it is, and after that, we also maybe witness the emergence of this state, which has somehow become a mandate of the European Union as well. So we have also experienced throughout these years, since 1997, when Dayton Peace Agreement was agreed, how the EU could manage actually to run such a state, okay, which has come out after the Yugoslav wars. The second reason why I chose Bosnia is because after I received my BA degree in international relations, I went to Bosnia, so this was just right after the Dayton Peace Agreement. For me, it was obviously I was an IR student while the war was continuing, and being half Cypriot, it was very interesting for me because I also come from a family who have been refugees. So and there were many interesting cases. You know, this Yugoslavia has been an ex-Ottoman space, like Cyprus. Similar cases, similar stories. So I went there to work as a volunteer when I was 21. So it was just right after the Dayton Peace Agreement. So obviously there were a lot of NATO soldiers. The country was divided. I mean, each NATO country was actually controlling one part of the country. So it was very interesting, kind of the NATO countries who were considered pro-Muslims were based in the Bosnian areas, Bosniak areas. The countries which were considered somehow pro-Serb NATO countries were based in the Serbian areas and all that. So obviously because there were so much soldiers and S4 was there, that the conflict was frozen. I mean, there was no conflict, and since then there has been no conflict and violence and atrocities, but it was very difficult to move. It was not considered safe, okay? Even though at that time, being, for example, as a Bosnian Muslim, to go to the Serb territories or to pass to the other side of Mostar, to the Croatian territories, at that time, I'm talking about just post-Dayton times, that it was not, people didn't feel safe. Obviously, this was just after a very violent war that took place, so a lot of people obviously had a lot of fear. However, much later, it has been the case, it's also very interesting, that refugees, displaced people, could return back to the places where they have been either chased or they experienced atrocities. And they started to live together, sometimes with the perpetrators of these atrocities. So this was an interesting case, in a sense. The Dayton Peace Agreement actually is interesting because as has been explained here, the Constitution institutionalized all the ethnic divisions, okay? So it hasn't only made these ethnically cleansed territories legitimate, but it has made all the ethnic divisions of the war institutionalized, privileged political status to the Bosniaks, Croats, and Serbs, while mentioning them in the preamble, and it left others. And it's interesting, just like, for example, Cyprus, because we are always talking about Turkish Cypriots and Greek Cypriots, but I wrote an article years ago when I was doing my PhD, writing my PhD thesis on Cyprus, the other Cypriots, because obviously there are the others in Cyprus who are also concerned by the Cyprus problem. And with immigration and with the settlers and all that, these other Cypriots have multiplied. They are not the original communities. You know, it's not the Latins, the Maronites, and the Armenians anymore. But we have other Cypriots who are also concerned by the Cyprus question. So as this was the case for Bosnia as well. So there were Jews, there were Roma, there were other communities living, And this, because this Dayton Peace Agreement concentrated mostly on these ethnic divisions between these three warring parties, it kind of left the others. That's why they went to the European Union and to the Court of Justice, and then there were a lot of problems with the Dayton Peace Agreement because of that, because it was against their constitutional rights. So in this case that I find this very interesting, but it's also, even though despite the institutionalization of these ethnic divisions, that in 20 years, Bosnia could achieve the right of return. I mean, this is the return of the displaced people, somehow. I mean, there were a lot of exchanges and all that, but there are, and the more and more I see actually documentaries, I'm interested in, because I work with the refugees, and their parents now are going back to the territories that they were chased from, especially in eastern, where the territories that stayed in Republika Srpska. So, what I find about this article is that I think that it's a very good account of what had happened, and it's a very good account of all these constitutional arrangements, so it's very informative. Perhaps I was just thinking that, so there's a criticism of the Dayton Peace Agreement, but there is not enough problematization of what could have been done, what else could have been done. So I think this is kind of lacking in this chapter. So in this sense, I thought, yes, as if it's shown that this Dayton Peace Agreement and the constitutional arrangement is shown in this chapter as the biggest problem of the kind of the paralysis that Bosnia has been living through. But there's also another problem there that hasn't been touched upon. Obviously, this is not the topic of this chapter and of this book, but why, for example, all the Bosnian people who are living in this territory could not actually eliminate this problem of ethnic divisions after 20 years? One of the things that has been said, because Bosnia was never given kind of these economic incentives, like investments or whatever, like Germany, for example, was given after the Second World War, in order to really reconstruct the country. So it has become a kind of a mandate, an economically dysfunctional country, a country that only lives on aid. And this kind of didn't bring, for example, didn't create workspaces or even factories or places where people could work or could also incentives perhaps to invest together, to do such things. So it just left the country, it was economically not very well functioning. So I thought this could also be a reason, for example, socioeconomic reasons could also be the reason why these ethnic divisions this problem of ethnic divisions was never solved. So this hasn't been quite problematized. So I find this, I mean, maybe it could have been, this discussion could also been brought to the fore in this chapter. So the other case I chose is Ethiopia. And there are also two reasons for that. One reason is because I was curious what's happening in this country. I didn't really know that much about that there are actually these kind of constitutional arrangements, territorial arrangements also in Ethiopia. But at the same time, since I had my PhD degree in political geography, when I was a PhD student, I read a fantastic book about the iconography of the fascist Italian time in Ethiopia. So I just, because I remember that, I said, okay, I'm going to choose this chapter in order to see what's going on right now, because I know the history. So again, it's kind of a very good account of the background of the ethnic conflict, what the problems that Ethiopia has lived through. And here, kind of, it's a bit different than, obviously, what happened from Bosnia. But here, what is being said, actually, what is being argued here is also kind of the contrary of what happened. Or the author here has talked about the socio-economic incentives given by the central government to the regions, so to the federal structures, as a reason why there hasn't been any separatism, kind of, because these kind of services that have been provided by the central state For example, here, the author says that probably for Ethiopia and probably many other developing diverse countries, the state's ability to deliver much needed services on an equitable basis can be fundamental in undermining the secessionist movements. So again, I was like happy to see this, and I also find this chapter more analytical than the others, not only concentrating on the constitutional arrangements in Ethiopia or whatever, but looking at how the central state actually could maintain this federal structure and could maintain the balances between these different, between the divisions, the ethno-nationalist divisions that exist in this country, especially among the regions as well. So delivery of the services, for example, was considered here as a good reason. So it kind of stimulates the reader to contemplate where, at the end, socioeconomic reason, socioeconomic kind of situation can be the solution to ethno-nationalist divisions after some time. So this is some kind of a current theme that comes to the Cyprus question as well, right? But then I was thinking, is this the only reason if we don't have socioeconomic problems in a country, or if these problems are resolved, does it mean that we don't have ethno-nationalist feelings anymore, or the people are not separated along ethno-nationalist lines, okay? So this is a kind of a very more economistic, even so some kind of a Marxist approach. So then I was just thinking, are there any cases that we can see now? So it's kind of the exactly opposite of what I thought about Bosnia. Are there any examples we can see now that a secessionist region, a secessionist part of a country in the in the world, which doesn't go through any kind of socioeconomic problems, on the contrary, but still they have a secessionist claim? So I thought about the north of Italy, for example. I mean, it's the richest part of Italy. Padania still wants to separate. I thought about Catalonia, for example. Catalonia is a good example of this. And then, so when you consider, or the northern Iraq, for example, the Kurdish part. So it's now they had the oil. I mean, it's kind of different, obviously, from the other cases. But these are the places where their claim for secession is not based on economic reasons, socioeconomic reasons mainly. Actually, they want to keep their wealth. They don't want to share the burden. So then I thought that this is kind of a good chapter then, if you read. So the book is great in order to, because it gives a chance to the reader in order to compare, yes, in this case that this is a problem, in the other case this is not a problem, but it complicates the problem and all that. So it kind of stimulates the reader, I think, to think what are the reasons of ethno-nationalism in the end, and what can be the potential solutions. So actually maybe there could be another book written after your book, really, on all the reasons, psychological, economic, or all the other reasons, which actually lead to these problems, because these would be the root causes of conflicts. So actually, maybe there will be a series after this book, when I'm just thinking. So in that case, I found this book very stimulating, and the case studies, and I recommend it to the scholars and students of international politics. Thank you.
Thank you very much, Emel. Thank you very much, Iris and George. Before giving the chance to George to reply, I'm sure you have a lot of points to make. I have a lot of questions myself, but I would like to ask some questions from the audience, and maybe we collect those, and then you... yes, Haris.
Yes, thank you very much. I definitely need to read the book. But I heard an argument, and I'm not sure who to attribute the argument to. But anyway, the argument, I guess, was that when you do not have a population balance, and the population is, there is a great population imbalance, let's put it that way, then consociation or power sharing becomes difficult. And, in public discussions here in Cyprus, you often hear the counter-argument that why doesn't that then become a problem in the context of European Union, when Cyprus has less than 1% of the population and it still retains veto rights in a lot of decisions? So that would be my question.
I'm always an optimist. I never give up. I'm getting close to it right now, but I never give up on anything. I dislike the idea of a gradual implementation of a solution that, George, you mentioned. There are many reasons for that, not least because the Republic of Cyprus will disappear in the transition. And if something goes wrong, you cannot use the new state of affairs to deal with it. So you have to sort it out in detail from the beginning. As we mentioned earlier, how can you convince people that it's safe to go and live in the other area if you don't have mechanisms in place to help that? If you don't sort out what happens to the children, if you don't sort out education, if you don't sort out the other things. Now, the other reason is the terrible case of the peace agreement in Israel and Palestine, where Rabin was killed. We were expecting Arafat to be killed as a traitor to the Arab cause, but it was Rabin who was killed. And the whole agreement turned upside down as a result. So basically I'm saying do it properly, get things in place. There are certain aspects where you can make progress. For example, if we are to solve the problem in Cyprus, the Turkish Cypriots have to adapt to the EU laws and regulations. They estimate they need 7 years to do that. 7 years are not there to do that. It should have been started 10 years ago. I think in '91, they announced their program for this, and it was never implemented. And yet, financial resources are being provided by the EU, which should be concentrating on this issue. Okay? So there are things you can do to move in that direction if you agree on them. And I've no problem with that. But you don't move to the solution until you have everything in place. This is what I'm trying to say.
Thank you very much, Costa. My point is on a similar line. And given your expertise in various ministerial positions in Canada, George, I was wondering about your view on how to finance the Cyprus question. I'm working myself on negotiations, and if I was advisor to the two Cypriot communities, I would tell them, if you're negotiating, you should negotiate also the package that will come to support the compensation, the same way we have run the experiment in Northern Ireland, and we had there the level of compensation that goes to the two communities in order to accept a settlement. So I was wondering, and given what you have said before about the imbalance, that imbalance can work at the advantage of the Cypriots. Firstly, because we're a small place. We are, for the Greek Cypriots, as the most economically advanced side, the Turkish Cypriots, the distribution will not cost us too much. We can estimate the cost. We can ask for others to contribute to the cost because of the strategic importance of Cyprus, the presence of British bases, EU involvement, negotiations between the UK and the EU. We shouldn't sell our cards in any of these negotiations for too cheaply. We should push our case the way the Irish have pushed their case and provide the cost. Plus, and this is a topic for tomorrow, if countries are contributing, they can be linkage with natural gas and oil. When I make my own negotiations in my school, we usually the language of underwriting. So there's always a possibility of the international community is underwriting some of the costs, 30, 40 billion pounds in compensations, and then they can get paid by the natural gas and oil if that is found, and when it's going to be found. And that gives an incentive for them to manage those issues effectively, and we get the funds to pay for the settlement.
Well, I'll sort of just work my way through a number of questions, and the first is the issue of imbalance, the relative size of the two populations on the island. I mean, I think we're seeing the fact that that is a salient issue by the fact that when you talk about consociationalism, you do have majoritarian issues, design elements that you bring into it. And in fact, I think that's part of what's interesting and unique about the design that you're developing here, is that because of the size of the Turkish population, Turkish Cypriot population relative to the Greek Cypriot population, you've had to do that. You've had to sort of balance those things in some way. You know, I think, Harris, your point about vetoes, everybody in the EU has a veto, so I mean that just goes with the territory. Be careful how you use it if you're Cyprus. I mean, I was at an event the other day in Ottawa where the Irish ambassador was talking, but I mean the Irish have made it very clear to the EU that they won't let a no-deal Brexit happen. It's so vital for them, and I think the EU agrees with that. So a very small country can have that kind of influence in very special circumstances. But the risk here is of a more generalized use, and also all the emotional tie-in that's associated with it. So I mean, I think you need a consociational agreement. I think you need vetoes for the minority, but part of why I'm a great advocate of pushing as much into the communities as possible is to limit the number of issues where you actually have to agree. And so I'm a great devolutionist within the structure of the kind you have here. The contrast with Northern Ireland, I mean, is that Northern Ireland has not been able to decentralize. I mean, the communities are too mixed up. And so they've been stuck with having to decide everything together. And in that sense, you have a real advantage compared to them. The issue of which you raised, Aristotle, about the unity of the state. I mean, there are two things at play here in the transition with Cyprus. One is that the Republic of Cyprus says there will be unity of the state. The Turkish community, the Cypriot community says no, it'll be coming together of two. That has been finessed so far. But what has not been finessed is that there will be constitutional rupture. You will not be approving the new constitutional arrangements within the framework of the Republic of Cyprus's constitution. You'll be giving it legitimacy by taking it to the people. And so that's the interesting legal structure that you've come up with here. I don't think the Supreme Court ruling, the European Court of Human Rights ruling on Bosnia actually has much relevance here. It had to do with the very narrow issue of the Jews and the Roma who were excluded. I think it won't be a difficult matter to structure a deal here which avoids that kind of problem, particularly if basically when the two communities vote, they vote on a territorial basis as opposed to an ethnic basis. So that if you're a Greek Cypriot living in the north, you will vote in the north, and if you're a Turkish Cypriot living in the south, you'll vote in the south. Now, I don't know whether that's the arrangement, but that would be the one. That would be the one. That would be the one which would be the cleanest one in terms of human rights. It would seem to me. We haven't talked about tonight, and I'm out of touch with where you are on the Charter of Rights, which is a critical issue that touches all kinds of things, but also the court structure. And I mean, the one thing I think is good about the Bosnian design, which I think you would you're looking at adopting is having one or two or three, I think it's three you're talking about, three international judges to avoid deadlock on the court. And somebody also said it provides a bit more assurance as well about the integrity of the judicial system. Dysfunctional agreements, we've got a number. I don't want to hammer away. I'm Scottish by origin, but I do think the UK sort of got itself into a dysfunctional agreement, and there are lots of dysfunctional agreements around. Sometimes that's the best you can do. Sometimes I think in the UK's case it was just because the English don't give these things enough attention. But the issue that is interesting. The UK is the only case of our studies, of our 17 cases, where a secessionist movement was told, yes, you can secede. In all the others, and Tom Ginsburg in his chapter talks a fair bit about secession, which we don't really go into too much, and arguably that's the missing option. The fifth option, I've talked about these constitutional design options, but the fifth design option is secession. And it's off the table in so many countries. It's off the table here. You could make a very good case. It came close actually at one stage. I think the Americans supported, if my memory serves correctly, back in the 70s, they supported the idea of dividing the island into two sovereignties. It would actually be the simplest solution, but it's not accepted. And the international community doesn't like it because it would be seen as a reward for aggression, and the Greek Cypriot community doesn't like it because they don't like to lose half that part of the island with which they identify. I come from a country where we played, and I personally was very much involved in it over many years, we've played a very sophisticated game around secession, and we have not admitted that we've admitted that it can happen, but we've really we've avoided the kind of simple-minded thing which happened in the UK, which just says 50% plus one and off you go. But I understand how that happened in the UK, because in the UK, the first decision on the right to secede was in Northern Ireland as part of the Good Friday Agreement, and it was hard to imagine saying anything other than if the majority wanted to join the Republic, they could. It would be civil war if it happened at 50% plus one, but I can understand how the principle was put there. When you brought it to Scotland, it's a whole other issue, and I think now that people have seen what the complexity associated with breaking up a country which is integrated, it will change debates around secession everywhere. For that we can be very grateful to the United Kingdom for providing an abject case of the problems of secession. I'll just make a comment about one comment about Bosnia and another about Ethiopia. Bosnia, I don't think, in a sense it ratified ethnic cleansing, but as you said, but there actually have been efforts since to permit people to return, and there's been a relatively, there were facts on the ground that had to be dealt with, and people had to stop a war, but the worst parts of it were the things that went to the European Court of Human Rights, and they could have been avoided if they'd been a little bit more nimble. Ethiopia is an interesting case where they federalized the structure of the government constitutionally, but from 1992 until very recently, it was very much a dominant party system, quite centralized within the party, and the party was made up of a coalition of rebel groups from different ethnic groups, but they had excluded, at the time they wrote the Constitution, the Oromo Liberation Front, the Oromo being the largest population in Ethiopia, right next door to Addis, and that's been part of what's been driving change in Ethiopia over the last couple of years, is the discontent of the Oromo, and all of a sudden, the politics of Ethiopia is becoming truly federal, in a way that it wasn't during the period when the EPDRF sort of was dominant in what goes on there. I think how to finance. I'll respond to your question on. Again, I can't say what the details of the property package were that I looked at, but there was a lot in the property package about how to finance the transition. And the basic idea was certain arrangements could be made which could cover a fair bit. I mean, when you talk about the $35 billion, I mean, the estimate was that just one measure might do a quarter of that. And then there are other measures which might have taken you another fair bit down the road, not to 50%. But I think there's also a question of whether what Cypriots think they're owed, the international community think they're owed, or whether Cypriots might have to put a bit of water in their wine in terms of what the cost of the transition is going to be. But my expectation is the EU will be the principal funder when the time comes, and then there's also the Turkey too. I think will reasonably be expected to do something. But there again, I mean, why wasn't the property package made more, ventilated more? And this goes to and in terms of phasing, maybe you couldn't implement the property package now, although arguably you could do some things moving in that direction. But you could start putting things out and phasing agreements as opposed to waiting till everything gets agreed. But there are many countries. I mean, South Africa went through having an interim constitution. Nepal went through having an interim constitution. I appreciate there's a distinction here, which is they didn't have to reunite a physically broken country. And so your point there is, I think, quite valid. But there are perhaps things that could be done which could be done without creating a risk of things coming undone and not being able to manage them.
Any other question? The last one for Mr. Constantinides? No, it's okay. It's okay. Please go ahead.
On the property issue,
Ed?
There you go.
Thank you again. On the property issue, there's no one who's going to compensate for something like 30 to 50 billion, which is the value of the land, right? There's no one could do it. The priority after a solution is the implementation of the agreement, which will cost a lot of money and needs programming. And it has to be done. I don't think it can be done in less than 7 years. And that's the priority there. Now, how you compensate the refugees and the others is a totally different issue. And there, I think there's a lot of state land which can be developed to compensate people. But it hasn't been thought through, and it hasn't been worked out in the negotiations.
Well, all I would say is, I mean, I know in detail what was done on the property package, and there's a lot was done.
I was involved.
Yeah, well, it has many elements, and
I didn't say it doesn't.
And it also has the potential to raise significant money.
Look, let me put it, my calculations on the value, or if we take the Annan plan, the value of the land that was under territorial adjustment is over 50 million. That's under territorial adjustment. That's what would be given back to the Greek Cypriots. No one ever announced the benefits that would go to the Greek Cypriots from that. So the property in Cyprus is very expensive, and no one's going to pay that sort of money. The European Union has said, in the event of a solution, it's prepared funding of about 3 billion. It's useful for implementing the agreement, And that is what we have to do. We have to make the agreement work. And that's where we have to concentrate. The compensation can be worked out, and there will be a committee to do that.
Thank you very much, Costa. I think the opportunity of yes, sorry, Aris.
I don't know whether George would like to.
No, I don't think it was, but I don't want to enter
Okay,
debate.
so if I can have two comments or replies, one to Haris. Actually, the argument is not about not having generally a veto power or consociation not being a good thing. The argument that is put forward in the conclusions is that whenever we have one of the three constitutional designs, which is the highly devolved federal government with the consociational central government, then when there is a significant disparity of population, it is especially difficult. Okay, so there are quite a few caveats there. And I think that what we see in practice corroborates this conclusion. It is much more difficult than it would be if it was different. I can give one example, like we're having the concept of bisonality, and if there is to be, I'm not arguing that there will or that there should, but the Turkish Cypriot argument is that there should be a majority of population and properties. This can only be done if Greek Cypriots do not return. Sorry?
It's a joke. You're talking about a joke.
I'm talking about what the official position is. Okay, so if it is a joke or not, that's not up to me. So that would mean that Greek Cypriots would not. Very few will have to return, and very few will have to be reinstating their properties. Now, this could be accommodated only if there are a number of exceptions. And if there are a lot of exceptions, like there had been in the Annan plan, it will be much more difficult for Greek Cypriots to accept that they will be subject to exceptions in their rights and exceptions to their rights. So that is the argument that it is especially difficult when there is this disparity of population. It is still not impossible. It could still be possibly doable, but it is difficult. And lastly on that, we are talking about territorial cleavages. In the EU, we don't have such a thing. Okay, so we cannot compare how the veto works in the EU and the fact that Cyprus has one vote, as Germany has one vote. Perfectly correct. But here we're talking about territorial cleavages being territorially concentrated, politically salient, collective demands for constitutional accommodation. So it's quite different. And a second and last point on the Bosnia cases, actually on the remark by George Anderson that the Bosnia case was not really relevant for Cyprus. That was the first one, the Finci and Sejdic.
Oh, there was the property one, which was relevant.
That concerned the Roma and the Jews, and this could be comparable to what might be the case in Cyprus for the Maronites, the Armenians, and the Latins. So there is an issue there. It is not the most central, but there is an issue there. But after that case, we had another two cases, and the Zornic and versus Bosnia-Herzegovina and Pila. There, the applicant did not want to declare affiliation with any ethnical group. She wanted to run for the elections without being considered Serbian or Bosniak or whatever. And she was not allowed to. So, and this was found to be a violation of her human rights. So this is much more problematic when it comes to the Cyprus arrangement or would-be arrangement than the other, because that would run counter to the very concept of bicommunality and the fact that each community will official positions are affiliated in terms of communities. So there is still an issue there.
Well, what I don't understand is the thinking here that for Greek Cypriots living in the south, in the north, or Turkish Cypriots living in the south, they would vote with their ethnic community or with their territorial community?
They will vote for their ethnic community for the Senate.
Oh, that then risks being problematic.
Yeah. So there are other ways to circumvent that. So we can find another formula that circumvents that, provided that the sides are open-minded.
If I may, on that point, the initial versions of the Annan plan were considered of providing a breakthrough by doing away with that exactly and having the territorial unit as the determining factor. In the last version, after Dechtach's insistence, it was adulterated and the ethnicity, the community identity was introduced, and that broke things down. If I may, since I have the microphone, unless it's time to go for lunch and your stomachs are rebelling.
It's a very short question, please.
You know me, can I have a short question? It's possible. It relates to some of the points. Emel said that we had ratification of ethnic cleansing in Bosnia. If that was the case in Bosnia once, if one would say, it's 1,000 times in the case of Cyprus. And that addresses some of the issues that Aris has mentioned. We are talking about bizonality as a result of the 1974 events and the displacement of population that followed. And the issue of property and returning to your property and so on would not have been the case if the territorial arrangements were such to concentrate on areas where one community or the other predominated. More or less an amended Guinness 1974 map. And you could have two entities without necessarily being territorially contiguous. And there is no, I haven't seen any agreement, any parameter where it says specifically that bizonality means territorially contiguous state. And some of the Annan maps reflected that. They were not territorially contiguous. But if I may, Mr. Anderson, you talk about not implement things before everything is agreed. There is an issue there, a question of going ahead with agreeing parts and putting them in place, or agreeing the whole and then proceeding with a phased implementation. These are two different concepts that one has to separate. But in the case of Cyprus, to be more realistic about phased things is what we have been using in Cyprus in the sense of so-called confidence-building measures, where major, not petty things, but major things will happen. For example, the implementation of UN Security Council resolutions calling for Varosha to be put under UN administration and for the people to return, reconstruct the city, and in conjunction with that, certain material benefits accruing to the Turkish Cypriot community, including with regard to trade with the European Union and all other things. That kind of phased-in things can have an effect on the ground. So one may want to think along those terms. And I was going to ask you, but it's too late, where does Canada and Quebec fall?
Quebec is a very happy part of Canada, and there I end my speech.
Thank you very much. I'll show the very quick reply. There is dinner reception waiting for us outside. Please do join us. And thank you very much for attending.